Hi, everyone. Welcome to our webinar on the new franchising code of practice. My name is Annalise Catania. I'm a senior lawyer at LegalVision, and I'm joined by Cameron Graf, another senior lawyer in our franchising team. Before we begin today, just a couple of quick housekeeping items. After the webinar, you'll receive a recording of the slides in your email. Throughout the webinar, at any point, you can submit questions in the Q&A box, and please complete the feedback survey after the webinar that you'll receive. For the next 48 hours after today, you're also eligible for a free consultation with LegalVision. In that same feedback survey, if you pop your details in there, someone can contact you to organise that consultation. Before we jump into all the fun stuff, we'd really like to know what change is concerning people most about the franchising code of conduct. You should also have a poll on your screen. So whether that's franchisee compensation for early termination, mandatory reasonable opportunity for investment, the termination process and dispute resolution changes, changes to specific purpose funds, or if there's no real concerns about the changes, it'd be great to hear everyone's feedback before we jump in. So today there's a bit to get through. As you can see, there's been obviously some substantive changes to the franchising code, and we'll go through those key ones today. See them there. Ones to be aware of, really, the motor vehicle dealership clauses that now apply to all franchisees, restraint of trade changes, as well as penalty units are probably some key ones that clients are concerned about, along with specific purpose funds. So to get started, a quick recap of the franchising code. So not too much has changed here. Still applies to all franchise agreements defined in the code, except ones that are subject to other industry codes. Big one being the oil code. Oil franchises aren't subject to the franchising code generally. Still applies to food and grocery code or unit pricing coded franchises. The difference now is there's been clarification that certain pre-existing business relationships will not be subject to the franchising code. Needs to fit certain requirements there. So there has to be at least 2 years of trading by the franchisee prior to entering into that franchise agreement, providing similar goods or services. So if it's a grocery store franchise, presumably they were offering some sort of grocery beforehand for 2 years. If you think the sales are likely to be less than 20% pursuant to the franchise agreement, so presumably 80% of their sales will come from their pre-existing business. And if you think that will last for 3 years, so for at least 3 years, 80% of their sales will be from their pre-existing business, then the code won't apply. Obviously, quite a few caveats to that exception, but something to be aware of. There's also been some structural changes now in the overhaul. It's structured much more like normal, regular legislation. We've seen section numbers now instead of clauses and prior annexures. So disclosure document annexure is now a schedule, which aligns with the other legislation. Now, before we get into the more substantive changes, I can see a lot of you are concerned about the compensation for early termination, which seems to be a general theme, as well as the termination rules. So we'll touch on those at a high level later today. And then please, if there's any other questions that arise from those slides, just drop them in the Q&A box so we can address any real specific concerns if you feel there's more detail. First one, expansion of motor vehicle dealership protections. Prior, there wasn't guidance provided as to how service and repair works offered by motor vehicle dealerships would be captured, given there is a specific sections of the code that only apply to motor vehicle dealership franchises. We now have clarification. So if a franchise that is a motor vehicle dealership is providing service and repair work, that entire business is now captured by the new code. This will not affect if you're a standard franchise that's only doing service and repairs. You are now not a motor vehicle dealership, but it will capture the service and repair work done by existing motor and vehicle dealership franchises. On that note as well, there's previous provisions that only applied to motor vehicle dealerships are now going to apply to all franchises. And Cam will take you through those now.
Thank you for the introduction, Annalise, and welcome everyone as well to the presentation. So as Annalise mentioned, two of the biggest expansions of the motor vehicle dealership protections to all franchise businesses are the early termination compensation and the opportunity for investment. So I'm going to talk about the early termination compensation framework. A quick little bit of background. These changes were brought into the code in 2021 for motor vehicle dealerships to really deal with the situation of car manufacturers leaving Australia and close the networks and the impact that had on the franchisees in the network, given the long time horizons and investments that they made in their businesses. The 2023 review of the code suggested expanding this protection to all franchise businesses, and they basically copied and pasted the provisions for motor vehicle dealerships and said they'll apply to all new franchise agreements. It's actually from November this year onwards. Now, if you're not familiar with the laws, the rules say that a franchisor closes the network, its agreements must have a provision for compensating franchisees, and I'll go through that in a bit more detail. And the types of closures include a withdrawal from the Australian network, a rationalization of its network, which, although it's not really defined in the legislation, is understood to mean changes to a structural rechange or be mergers, splits, etc. of that business. And it also includes changes to the distribution model, which again is usually meant to be quite a significant change to how the business is operated. We hope that there will be more information about the exact wording and interpretation of some of these clauses, particularly the changes to distribution model, because some franchisors might be worrying, what happens if they add or remove minor services? Will this be captured? It's definitely good questions to be asking, but we're hoping that before 1 November, when these changes actually come in, either the ACCC or the government will give a little bit further advice, because these clauses haven't actually been tested in court yet. So even though it's open for interpretation, there are still some considerations we can look to for the history, the purpose behind the clauses. But if you are looking at major changes, or if you're in a franchise network that is having major changes, start looking ahead as you update your agreements for November onwards, start thinking about the actual framework. Now, I mentioned that the compensation framework needs to have a few factors, and this is what the code says. Again, this is not an exhaustive list of what the compensation calculation needs to include, but it must touch upon these areas at the very least. So you've got lost profits from direct and indirect revenue. You've got unamortized capital expenditure, which again was very relevant for motor vehicle dealerships and the investment they put into those businesses. Lost opportunity in selling established goodwill, and winding up costs. Now, we've spoken to a few different clients about this, and also internally, and some people have wondered, do I have to provide provisions for all of these? The rules say you have to consider and set out how the compensation will be calculated, taking into account these factors. So it could be possible to say that it will be based off lost profits for direct revenue, but not indirect revenue, or the capital expenditure will be dealt with in certain ways, etc. So there's no hard or fast rule yet on how this has to be done. There's just been requirements you have to meet. And again, one key takeaway I'd say for anyone who's looking into this is that the code requires the franchise agreement to have this provision that covers these factors, but the code doesn't give you the answer. The actual franchise agreements that you sign with franchisees after 1 November, that contractual provision is what's going to set out the method. So it's to comply with the code, you need to make sure you have a provision. It needs to comply and mention all those factors, but then the franchise agreement is the one that will actually set out how that works. And then a final note, because I know this has been contentious in previous litigation, particularly the Mercedes dealers case that we've seen recently, the issue of goodwill. Just a reminder that goodwill can have different meanings legally and from an accounting perspective. And the Mercedes case, if anyone's not familiar with it, generally made this distinction that the goodwill in the brand that the franchisor can own is different to the goodwill that potentially is talked about here in this compensation framework, being the premium value that someone might pay to acquire a business above the book value. And that could be based on multiples of revenue or certain intangible goodwill in the actual business. And that's that accounting goodwill. So just keep that in mind. And Annalise is now going to talk about the reasonable opportunity for investment, which is the second most substantive addition to the code.
So from 1st of November, importantly, this change applies only to franchise agreements from 1 November this year, or any franchise agreements that are renewed or extended or transferred from that date. The franchise agreement has to provide franchisees a reasonable opportunity to make a return on their investment. What does that mean? It means both the initial investment that franchisees are having to pay and the ongoing investment. And it now puts a very clear requirement on you as a franchisor to proactively be looking at all fees franchisees have to pay to run their business and ensure that through the term of their franchise agreement, they will have the opportunity to make back the investment and the money they've put in to operating that business. Importantly, a concern we hear about this a lot is thinking it means you have to guarantee they're going to make back their money, they're going to get a profit at the end of this. That's not the intention of the clause at all. Remembering where this has come from as well, it's come from the motor vehicle dealership provisions, where the intention there is to ensure franchisors are providing a long enough term that there is, importantly, a reasonable opportunity to make back that money. This is really trying to stop franchisors really giving a 2-year term where there's initial investment required and there's evidently going to be ongoing costs to running that business. So we're not looking at here you providing franchisees a guarantee that they can make money, but making sure that you've looked at the financials of running that business and that the term you're providing franchisees could reasonably give them the opportunity to make back that money. Realistically as well, under the good faith provisions, this had been touched on at times, and you should have been doing this in your franchise network anyway. Now it's just clearly spelled out. So it shouldn't be too difficult. Just know there's the actual requirement now. Cam now will take us through specific purpose funds, which is quite a big overhaul.
Yeah, the extra wording in the code always makes us exciting. So if anyone's looking at and saying, what is a specific purpose fund? The code has defined, basically changed the definition of marketing and other cooperative funds. It's incorporated that into a slightly broader term called specific purpose funds. So they can mean the same thing, but it includes any kind of funds that are used for a specific common purpose relating to the operation of the franchise business. And the updated code does include some examples. So they've said marketing funds are included, specific purpose funds, and you can have cooperative funds to deal with technology upgrades or information technology and platforms. These can also be specific purpose funds, but there's no exhaustive definition or limit on what could be captured by this definition. So it is important that if you are collecting funds from franchisees and you're managing this and is for that specific common purpose, you need to think about whether this could be captured. And the reason being is that you now have to manage those funds in the same way that marketing other cooperative funds are currently managed. And that includes keeping funds in a separate bank account. It includes making contributions for any franchise businesses operated by the franchisor or its associate. It includes the reporting and auditing requirements and the voting that takes place. So there's a bit more requirements that kick in from November 2025 onwards, as well as information in the disclosure document that you'll be producing later in the year. The one exclusion or one thing to consider if you are a franchisor who's wondering, is this a specific purpose fund or not, is you should look closely at the services that you provide direct to franchisees and also how you're charging for those services. And I think the key takeaway is you want to consider, am I managing a pool of funds, or do I have franchisees who are contributing with some, I guess, uncertainty about where these funds are going to go, or is it a direct fee for a service that I'm either providing or passing through? Because not all kinds of contributions will be captured. And we actually had a question that was asked about the application of specific funds to conference fees, and it's something that we're actually still looking into this internally, because that create some open-ended uncertainty about how these funds are being managed. And our recommendation is if you're managing this and you want to provide some certainty and transparency, you can certainly opt in to comply with them. But what we are hoping to see in the next coming months is some clarification for things like conferences and events or additional programs, whether franchisors actually need to comply with them. It's something that we've actually discussed with other law firms and other presentations, that the industry would like a bit more clarification on this. So thank you for that question as well. And just to clarify, the marketing funds and other corporate funds that you're already running right now, they still have the same requirements, including with the current disclosure document. So make sure you continue to comply with those. I think that's enough about specific purpose funds. Annalise, restraints of trade.
So restraint of trade provisions. Lots of franchisors don't like these ones, but unfortunately we've now had some more obligations put around restraint of trades. So under the old code, restraint of trade provisions just didn't have an effect if certain requirements weren't met. The big one in the old code was if no genuine compensation was provided, if the agreement was not extended. Now we've seen that revamped. So the new code doesn't allow the inclusion of certain restraint of trade provisions. That can be a restraint, that is basically a restraint of trade that would come into effect if the franchise had a renewal or extension option and was not renewed or extended. And if that franchisee was complying with the rules for such a renewal or extension and they still weren't renewed, and there's no compensation provided, that clause is now a breach of the code specifically, and the inclusion of such a clause now attracts civil penalties. In addition to that, there's now an additional section of the code which says if you try to enforce a restraint of trade that falls into those rules, you would also be subject to the civil penalty. So there's now kind of a double breach with penalties. Your breach for including it, your breach for enforcing it. Previously, the kind of approach was don't have it in there. If you do, it just has no effect. That's now gone. And we're looking at the breach as being the way to go. Civil penalties can be brought against you. The important thing to take away from here is really reviewing any restraint of trade clauses in your franchise agreement. There are certainly conditions where you can enforce restraint of trades, but they do have to be carefully considered. And certainly with these new additional requirements, we strongly recommend a franchise lawyer looking over those, where the simple inclusion could now be a breach.
And also sorry, Annalise, some of the changes of the code, they're trying to move away from having a legal override of provisions taking effect, and they're trying to focus more on the conduct. And so, as Annalise mentioned about the additional penalty, or not just having the clause, but also enforcing it, I guess the policy direction that we're seeing from Treasury and franchising industry is to try and discourage conduct that's not wanted, as opposed to getting too much in the way of whether a provision in a franchise agreement would have legal effect or not. So if you've noticed that change, then I guess it's a policy direction that they're taking. All right, well, speaking of new directions, so there has been a bit of a change to the termination provisions, I think based on some feedback from the franchising industry about I guess the intention of having a dispute resolution and clear termination framework was actually making life a bit more difficult and kind of missed the purpose. So one of the changes about the termination deals with the 7-day termination, which the franchising code sets out a few examples. We haven't gone through them here because you should be familiar with them, but can be for insolvency, for voluntary abandonment, fraud, dangerous operation of a business, those sorts of things. And the code says that if a franchise agreement allows a franchisor to terminate for one of these serious defaults, it has to give 7 days notice. The new code has expanded this to include some additional circumstances where a franchisor can terminate and has to give a 7-day notice. And that includes certain breaches of the Fair Work Act by a franchisee. It's important to note it's not just any breach of the Fair Work Act. This is where there's actually been proceedings against a franchisee where there's been a finding of a serious contravention of a Fair Work Act civil remedy provision. It's a bit wordy, but what's important for franchisors to realize is that it's not just allegations of breaches of the Fair Work Act, it's actual findings. And when we talk about serious contraventions, that also has an implication of a level of intention or recklessness to the actual conduct. So important that franchisors keep in mind that as they're reviewing their agreements, to make sure that they follow the wording of the code, and then when it comes to actually enforcing it, making sure that they've actually the conduct has met the threshold. And similarly with the contravention of the Migration Act, there are certain sections that the code has specified. So it's important to make sure that before you terminate a franchise agreement, which will be a new franchise agreement from 1 April onwards, you make sure that the franchisee has actually met this threshold. And if you think there has been some kind of judgment proceedings, make sure you get a copy of that judgment to verify that the certain provision or the type provision has been breached. And the other change that the new code has made is distinguishing what we consider between objective terminations and subjective terminations. Now, what do we mean by that? There's a current provision in the code that allows a franchisee to go to urgent alternative dispute resolution, or ADR, by lodging a notice of dispute during the 7-day termination window. And it basically says that the termination can't go ahead, it's put on pause, it has to go to ADR, which is commonly mediation, but it can include other processes. And the ASBFEO, which we'll talk about later, has to appoint them. The new code has recognized that this rapid deployment ADR should actually be limited to a couple of circumstances, which we've put on the right-hand side of the screen, where there is potentially an element of subjectivity into whether there's been misconduct or not. And this is where there's been an abandonment of the franchise relationship, where the franchisee has engaged in fraudulent activity, or where the franchisee has operated the business in a way that endangers public health or safety. And even though there can still be circumstances where a franchisor can stop the franchisee from trading during this period, that urgent ADR is limited to that. Obviously, franchisees can still go through dispute resolution process for all kinds of terminations, but the code is trying to avoid situation where a franchisee would be insolvent, become a Chapter 5 body corporate, which is pretty objective. Once you're changed on ASIC, you're insolvent, you're deregistered, there's not much point going through dispute resolution. The code has said that there's no need for rapid ADR if there's that sort of objective breach or misconduct. So I think it's trying to streamline. We'll see how it works, but this was a generally welcome change to try and avoid unnecessary disputes, which obviously costs everyone time and money. Now, I mentioned the ASBFEO as well. So they have an expanded power to publicly name franchisors who do not meaningfully engage in an ADR process or withdraw from an ADR process. Now, there are circumstances where an ADR process can be terminated by agreement or by the actual ADR practitioner. But the idea here is that given that franchisors and franchisees are obligated to take part in ADR, if a franchisor doesn't take part of it and breaches obligations, the ASBFEO, the Ombudsman, can actually publish the names. They can't publish any details of the issues of dispute or the allegations, but they can they have discretion to publicize the names. And the important thing to note is that this can be for any ADR process that commenced after 1 April, and it's backdated to apply to all agreements that are governed by the first version of the franchising code, so from 2015 onwards. All right, mindful of time, Annalise, why don't you take us through disclosure requirements?
Yes, so another welcome change is we can now say goodbye to the key fact sheet. I think franchisors and franchisees alike will probably be happy with that one. This will apply from 1 April. So if you're disclosing or entering into franchise agreements in the next month, you will still need to provide that key fact sheet. But from 1 April, no more requirement for a key fact sheet, which I'm sure everyone's quite happy about. Another amendment to really the disclosure requirements here is we have other webinars on this as well, but your disclosure document has to be updated annually, and that's the general rule, but there are some exceptions. One of the real main exception was previously if you had entered into one franchise agreement in the prior year and you intended to enter into a franchise agreement in the current financial year, you fell into that exception. You didn't need to prepare the disclosure document. Now it's been amended, so it's sorry, you did need to prepare the disclosure document. Now it's been amended, so if you entered into 2 or more franchise agreements in the past financial year, or you intend to enter into a franchise agreement in the current year, you will still need to prepare a disclosure document. So previously, you may not have had to if you'd only had 1 or no franchise agreements the prior year, but we've seen that change now. So it's an or rather than an and. And then significant capital expenditure. They really love to play around with these provisions. We saw this in our last franchising code update, and now these have been further expanded. Some of the big key items, significant capital expenditure will now capture things that generally wouldn't be considered that, given the ordinary meaning of the words being essentially everything in item 14, like 1A and 1B under the new code in your disclosure document. So we're talking about a lot of those upfront costs. And in addition to that, you need to now discuss the significant capital expenditure with franchisees. So it's not just a simple disclosure now. You need to have that discussion with all franchisees. It will also importantly apply to renewals or extensions. So any existing franchisees who might be renewed or extended after 1 April, they'll need to also have that significant capital expenditure discussed with them. Moving on, so franchisors now have a positive obligation to notify franchisees if they don't want to renew or extend a franchise agreement. Previously, we saw this obligation on franchisees, and now franchisors have a clear obligation, and it has to be at least 12 months prior. And the opt-out of the disclosure process. So we've also seen some wording changes here to certain provisions, but the first change is existing franchisees or transferees that might have a substantially similar or the same franchise business with you and have a similar franchise agreement with you can now in writing choose to opt out of receiving a disclosure document or a copy of the code for new franchises. We expect to see this in multi-site franchises, for example. You might be able to utilize this. And the second opt-out provision we've seen introduced is that franchisees can also opt out of the now called the consideration period, previously the cooling off period. So again, if a franchisee falls into that category, substantially similar or the same franchise agreement with you, they can opt out of being able to terminate during that 14 days after they sign the franchise agreement. And we've also received some clarification. Prior, it was a little bit murky whether a franchisor, whether the provisions about not signing in the consideration period applied to both franchisee and a franchisor. We've now received that clarification that it's a franchisor must not sign in that 14-day consideration period. So that is actually a very helpful clarification. If franchisees choose to sign in that period, we still wouldn't encourage it, but we now have the guidance that the penalties and the legislation is against franchisors. And we also have some more disclosure requirement updates.
We'll work around. So in line with some of the termination provisions for Fair Work proceedings, there's also additional disclosures that franchisors need to include in their disclosure document, and any materially relevant facts which can be disclosed throughout the year about proceedings commenced by a public agency and judgments and breaches of the Fair Work Act, particularly in relation to the vicarious liability that a franchisor can have for the franchise network. So important to keep in mind of how this might relate to your network. And in terms of the financial disclosures, there's a new requirement that if there is a new statement solvency, financial reports, or audit reports that become available after you've given a franchisee your disclosure document, but before they sign the franchise agreement, there's a new requirement that you have to give it to them as soon as practicable and before they sign. And the explanatory statements say that because this could be key to a franchisee's decision to go ahead with the franchise or not, if you have these new financial disclosures, even if the franchisee hasn't requested it, you need to give it to them, and not giving it to them could be a breach of the code. And then finally, there's been a slight change to the approach for the inclusion or exclusion, I should say, of the details of former franchisees. Under the current versions of code, you were allowed to include the details of former franchisees unless they opted out and request those details not be disclosed. And there's also some restrictions on having residential addresses in there. The new requirements clarify contact details and information about the franchisee, but there's a new obligation of franchisors to actually write to the former franchisee at least 14 days before their information is included. And you can't include the details unless you have written to the former franchisee, given them 14 days. And if they write back to you and say, yes, I'd like to opt out and please remove my details, then obviously you have to remove it. So as a franchisor, you need to be mindful that you can't influence their decision to include or exclude their details as currently required, but you do have a positive obligation to give them 14 days notice and draw to their attention that they can opt out. And if you fail to do that, then you can actually breach the code again. So a little bit more work for franchisors, but again, this should only apply for franchise agreements that end, I guess, that are entered into and then end after 1 April 2025. We don't think it'll be retrospective, so you don't need to go through and speak to all the former franchisees. If we get clarification and the laws actually do want us to do that, we'll let everyone know, but it shouldn't be too complicated. Just make sure that if you have sort of your end of franchise communication letter or checklist that you use for your networks, make sure that this includes that kind of notice saying to former franchisees you can opt out. Right, Annalise, can you talk about legal costs?
So legal costs, again, this was one of the changes we saw most recently. So we had the introduction of a prohibition on legal costs outside of drafting, negotiating and executing the franchise agreement. And there was an obligation for those to be fixed legal costs. We now have some additional requirements to add on to that, where guidance is being provided that those fixed legal fees have to be reasonable and genuine. We imagine this has come from even personally seeing franchise agreements where legal costs could be considered inflated, and really just the desire to have those be a reasonable reflection of what lawyers are charging. Basically, the new sections that come in are similar to restraint of trade provisions, and as Cam highlighted, we've seen now a turn in the legislation where there's a breach for inclusion of these penalties that are in breach of the code, and there is, in addition to that, a penalty affiliated with you actually charging the fee. So should you have a situation where your fixed legal fees were considered unreasonable and you charge that fee, you ultimately could be breached under 2 separate provisions of the code. So it is really important now, given that added penalty attached to it, that we're ensuring that your legal costs are actually reflecting what you're being charged, and that they're fixed in the franchise agreement, and you're not trying to charge for anything beyond entry into the franchise agreement as well. And on the penalties, to do with all of that fun stuff and all the changes we've spoken about, there's now, some of them we've touched on, a breadth of obligations in the code now have the penalty of 600 penalty units, which currently equates to $198,000. So that's quite a bit of money if we're talking about a lot of those now triggering 2 of those penalty unit clauses. Some of the big ones that now have that 600 penalty unit attached to them are kind of set out here. Just be aware of discussing the significant capital expenditure is one of them. That's something to be aware of, as well as the reduction of former franchisee details who request removal, restraint of trade and legal costs we've been through, and also a kind of big one that kind of touches on many areas of law is the general release from liability or waivers in franchise agreements. We expect that a lot of franchisors will need to revisit their franchise agreement and ensure they don't have a kind of general release from liability or waivers, where they were quite common in franchise agreements, particularly before the unfair contract term changes that we saw come in consumer law. And now on to the fun part of when do these all apply and working that out based on the lovely legislation we've been handed.
I mean, some very interesting flowcharts, which I'm not going to share today. But the key thing that everyone needs to keep in mind is that there are a few different timings for the application of the new regulations. So we've talked a lot about new agreements from 1 April 2025, and that could be a new franchise agreement for a new franchise business, but it'll also include a situation where there's been a transfer, a renewal, or an extension that takes place on or after 1 April 2025. If that happens, the new code of conduct will apply. Now, the new code also applies to the conduct relating to the renewal, transfer, or extension of an agreement that's going to take place after 1 April 2025. And practically speaking, for the next month, you need to be mindful that if you're going to be, let's say you're going to be giving them disclosures before the date, but then you actually have updated financials after 1 April 2025, this is where we need to start thinking and looking in more detail of actually, do I need to give the extra obligations? I would say this is probably one of the most confusing aspects of the code, because the new code makes a distinction, says that if you give the disclosure document before 1 April 2025, so 31 March or earlier, you've got specific protection saying that will be sufficient disclosure. But if you there's nothing that says that disclosure after 1 April will have any exceptions. We might receive some more feedback from the ACCC or from Treasury, because there was meant to be a grace period, but the law hasn't actually included that. So right now, the key takeaway for franchisors is that if you do it before 1 April, you can be under the old code. If you do it after 1 April, you actually need to start updating your documents and make sure you're complying with the new code, even though there are certain provisions such as the early termination, compensation, the reasonable opportunity for investment, and specific purpose funds. These don't kick until 1 November and subsequently don't need to be in your disclosure document. Similarly with, I think, significant capital expenditure, that change doesn't need to go into your disclosure document until 1 November. There will likely be changes to your disclosure document, especially with the change from clauses to section numbers and revamping your franchise agreements. So the outcome is you could have to change your disclosure document twice during this year if you're doing grants between 1 April and 1 July, assuming that your financial year ends in 1 July. And as I mentioned as well, the ASBFEO powers to name franchisors can be backdated. If you have any questions or concerns about this, book a consultation with us. It's a one that we would love to cover more time on. And this slide, sorry, just kind of clarifies some of the, I guess, some practical guidance on when you should update the documents. Obviously, you can always opt in and start complying earlier on, even though some of those provisions may not take place until November 2025 onwards. You can certainly start and include those earlier if you wanted to. That's your discretion, but there's no obligation to include it, and franchisees don't have the right to have that in. So keep in mind that there can be some duplication. We got a question from Michael, which has a disclosure document, sample disclosure document been released. Yes, the new code has at Schedule 1 the updated version of the disclosure document, so that has all the changes. I mean, there hasn't actually been too much substantive changes to the wording of it. A few extra sections, key fact sheets gone, but practically it follows a similar format. The numbering has changed a little bit, so you have to keep in mind of that. But you can take the extract from the back of the code. Yeah, as I said, feel free to chat to us after the webinar, because this is something that can be complicated. And what we usually say to clients is, if you're starting to have conversations with franchisees now who are either renewing or transferring or entering into new agreements, if you think that it's going to be signed after 1 April, especially if you're only giving disclosures now, this could be a 14-day disclosure period, consideration period, plus potential for negotiations or changes. You really want to think about, do we want to avoid a situation where we're almost ready to sign on 30 March, but then actually we tick over to early days in April, and all of a sudden we have to redo everything and make changes, and how that's going to affect that timing. So keep that in mind as you go through this. All right, well, that covers a lot of content. As I said, the slides will be said. We've actually put together a publication which you can access here get the link from the slides when they're sent around, which summarizes the 2025 franchising key developments. Again, just a high-level reminder of some of the core changes. We are also in the process of updating our substantive publication for franchisors and I guess franchisees as well. We are waiting for some more guidance on how some of the laws will apply, especially around the early termination compensation framework. But once that comes out, we get a bit more guidance. We'll be updating that publication, which is kind of our go-to resource, and that will be available online as well. We do have some other events coming up in next week. Yes. There's a session run by our tax team, your tax and legal essentials for startups, planning your exit. So if anyone's in that space or want to get a bit of understanding about that, definitely go and check out that event. We love working with our tax team. They always provide a lot of interesting insights into both commercial and franchising world. And then finally, for those, some of you are already LegalVision clients, but if anyone is not yet a member of LegalVision, we recommend joining and having a look at what it can be covered in LegalVision membership. The way that we work is that we have 100+ specialist lawyers in-house to cover all your business as usual legal needs, to simulate what it's like having your own in-house counsel at a fraction of the cost. And the kind of things that we cover for franchisors is drafting and updating your franchise agreements for compliance, doing your annual disclosure document update. We'll do all franchise grants, renewals, transfers, assignments. We even do breach notices and termination notices, as well as looking at corporate structuring, trademark registration, as well as providing additional employment advice. And there's a lot that we put in there, knowing that when you are a franchisor, or even if you're a franchisee, there's a lot of other requirements that come into it. And the cost certainty that you get from having access to all the lawyers, we have found is a very useful way for franchisors to make sure that they're compliant with 2025 changes, as well as franchisees to understand what are their ongoing rights. So feel free to request a free consultation if you're a business owner, if you're an in-house counsel and you need a dedicated service for your high volume needs, or you're a franchisee looking to acquire or purchase a business, let us know, request a free consult, and you can put your details in at the end of the survey to chat with our team. And I think we've addressed most of the Q&A. We did get one extra question about legal costs, how this works for in-house counsel. The code doesn't say whether legal services are kind of in-house or not, and actually there's the cost of legal services. So if a franchisor has an in-house legal department and they've they've costed that department for the time it takes internally for the preparation, negotiation, and execution of franchise agreement, then as long as that's a genuine and reasonable estimate of what those actual costs of legal services are, that's something that definitely could be explored. Obviously, in-house teams normally don't invoice their boss. I'd be surprised if they did. But from an accounting perspective, if the franchisor has gone through and worked out what costs we want to actually attribute to it, I do not think that would actually go against the code. Right now, there's no requirement that it's actually externally. So I hope that answers the question. If there are any other questions, feel free to send them through. We've got a little bit more time. And Annalise, do you want to take us through? I think we did have some questions before the webinar.
We've had some pre-submitted questions as well. One of these was specifically what requirements are required by existing franchisors with existing franchisees. Can summarize that a little bit, but really there's no material effect on the relationship between franchisors and existing franchisees until they're renewed or transferred. Then the new code will apply. The ones that will kind of apply now, the main key one is specific purpose funds. So we definitely recommend looking at if you're operating a collective fund for any specific purpose, particularly where we don't have too much guidance right now as to what would be excluded from that definition. Looking at whether you will fall into that specific purpose fund, and then that additional disclosure, which aligns with the old marketing fund requirements, will need to go to all existing franchisees as well. There's also a question about what new requirements are required by a franchisor in appointing new franchisees. Really, the big difference here is the disclosure, like the actual items that have to be discussed on disclosure. Disclosure process is very similar, unless, of course, they opt out if they're an existing franchisee. In addition to that, now we have that discussion of significant capital expenditure in person. So it's something practically, if you're a franchisor, you need to look at, and I would be rolling out now, probably rather than waiting. There's no, as Cam said, it's very easy for these things to roll over into April. And it's definitely much better to have that discussion now and comply with the clause. And then we have, this, if there's anything that would affect termination of franchise due to loss-making store. Again, nothing in the old or new code allows for termination due to unprofitability. As we said, that return on investment clause doesn't actually mean that if you're not making money, there's a breach by the franchisor. So there should really be separate discussions there. There's the early termination provisions you could rely on, but otherwise there's nothing else. We don't have any other questions, then we might wrap this up. We have actually had a question that might be good to answer, circling back if LegalVision is limited to Australia. I guess for everyone online who might not have looked at LegalVision's website, we do actually operate in New Zealand and the United Kingdom as well. So we have lawyers in those jurisdictions and a newly formed US lawyer as well. So certainly cross-jurisdictional, and we do quite a bit of that work, myself and Cameron personally. We might just wrap it up now then. We won't have time for any other questions, unfortunately, but as we said, you will get that survey at the end. Feel free to kind of pop your details in there so we can have a consultation and see how we can assist your business. And we would really appreciate if you could complete that survey, value or feedback to see, hopefully it was useful. We understand it's a lot of information to digest, and thank you all for joining us.
Thank you for your time.